Hello and welcome once more to The Bench Report. You're listening to Amy and Ivan. Next in our series on the workings of the UK Parliament, we look at the sub judice rule. Now, at its heart, sub judice is a Latin phrase. It means under a judge. What that means for Parliament is that it restricts what MPs can actually discuss if something's actively before the courts.
Exactly. And the fundamental reason for this rule is, well, it's vital for justice, really. It's designed to stop discussions in Parliament discussions that get a lot of publicity, carry weight from potentially influencing or prejudicing a court case, or a judicial inquiry for that matter. You can think of it as Parliament trying to balance two key things: its own right to free speech, which is absolutely essential, and the need for everyone to get a fair trial, which is equally critical.
That sounds like a tricky balancing act.
It certainly is. And applying the rule, making those calls day to day, that falls heavily on the Speaker of the House. It's a big responsibility during debates.
Right. And this rule, it isn't brand new, is it? It has some history.
Oh, yes. It was properly formalized by a resolution in Parliament way back in 1963. And there were some tweaks later on, I believe in 1972. But things obviously change.
So Parliament's had to revisit it since then.
Definitely. The really significant changes probably came in 2001. That was after a joint committee. Commons and Lords together looked into parliamentary privilege generally. You know, the rights MPs need.
Ah, okay. And what did those 2001 changes do specifically?
They were quite substantial. First, they made it crystal clear the rule applied to parliamentary committees too, not just the main chamber debates. That's important because committees do a lot of detailed work. They also, crucially, clarified exactly when a court case is considered active in parliamentary terms, so setting clearer start and end points for the restrictions.
That makes sense. More clarity helps everyone.
Yeah.
But wasn't there also a relaxation of the rules in some areas?
Yes, that's right. It wasn't all tightening up. Subject to the Speaker or the chair of a committee agreeing, it became potentially possible for MPs to discuss ministerial decisions even if they were under judicial review.
So when the courts are checking if a government decision was lawful.
Precisely. And also, they could potentially discuss cases related to matters of major national importance, things like the economy, public safety, that sort of thing.
That feels like Parliament asserting itself a bit, doesn't it? Saying some things are just too important not to discuss, even with court action ongoing.
It does highlight that constant tension, yes. And because getting that balance right is so challenging, the rule's been looked at again since 2001. The Procedure Committee, they're the MPs who examine Commons rules. They reviewed it in 2005 and then again in 2006.
What came out of those reviews?
Well, they considered applying the rule to coroners' courts, for instance. And one concrete outcome was giving the Speaker the explicit power to tell an MP to sit down if they breach the sub judice rule during a debate. A bit more teeth for enforcement.
Okay, so that brings us almost up to date. But I understand this is a very recent development.
Indeed. Just this year, 2025, the Speaker has asked the Procedure Committee to review the rule again.
Another review. Why now?
The specific question this time is whether the rule is still, quote, fit for purpose. Essentially, does it work effectively in today's environment?
What's different about today's environment?
Well, think about the speed of news, the 24/7 media cycle, social media. How does a rule drafted decades ago cope with that? Plus, the sheer complexity of legal cases that touch on public policy. So the committee is asking, does the current system still protect trials properly? And does it do that without unreasonably gagging Parliament on urgent public matters?
It's that balance question again. Protecting fair trials versus allowing necessary democratic debate.
Exactly. It's a fundamental question about the boundary between Parliament and the courts in the modern age.
So it's clear the rule is vital for the separation of powers, for fair justice. But you can definitely see why MPs might find it frustrating sometimes when trying to debate really crucial issues that happen to be in court.
Absolutely. And as this latest 2025 review examines if the rule is still fit for purpose, it leaves a key thought for you, the listener, to consider. In this incredibly fast-paced, information-saturated world we live in now, what do you think are the biggest hurdles Parliament faces? How can it ensure trials remain fair while still enabling elected representatives to discuss the pressing public issues that impact all our lives?
As always, find us on social media at Bench Report UK. Get in touch with any topic important to you. Join us tomorrow for an episode on ministerial codes and compliance. Remember, politics is everyone's business. Take care.
Hello there. This is Tom, the producer of The Bench Report. Listener suggestions are vital to my mission of making politics more accessible and accountable. So, if you have an issue that's really important to you, personally or professionally, and want to know what those in power are doing about it, please get in touch via email or via our socials at Bench Report UK. I'll grab another coffee and start scanning those parliamentary archives.